Good morning, crime community. I'm here to read out another chapter of Squeaky by Jess Bravin. We're going to jump right into it. It's called A Fool for a Client. As Sandy and Heather left the courtroom, three plainclothes detectives moved in. They arrested Heather for a probation violation stemming from her August 1973 conviction for shoplifting $7 worth of merchandise from a Sacramento Payless drugstore. Probation officers complained that Heather had neglected to keep updated to her whereabouts. Their recordings listed as residing at the Phoenix House Drug Rehabilitation Center, one of at least three halfway houses she had stayed in. We saw her picture on the front page of the Union and realized she had moved, said a probation official. The detectives brought their suspect before Municipal Judge Rothwell B. Mason, who 2 years before had sentenced Heather for the theft of a flashlight kit, two batteries, three containers of dye, and a can of spray paint. To ordered Heather released after she promised to get in touch with her probation officer. Lynn, meanwhile, immediately made use of her new freedom to speak to the press, calling a jailhouse news conference for that evening. She entered a visiting room on her pale blue jail uniform, red and white sandals on her feet, and took her seat on the prisoner's side of the plexiglass. She cradled one telephone handset by each ear so she could give interviews to reporters two at a time. Dick Walker and Sandra Good, along with the three deputies, watched the scene from the side. The news cameras rolled. Lynn was demonstrably emotional, pacing the floor, shouting, trembling, sometimes coming to the verge of tears. To B reporter Nancy Skelton, who could watch Lynn through the glass but not hear what she was saying, the theatrical scene was Marcel Marceau-esque. So who were on Lynn's interview list, heard her views on many issues? Some were predictable, and she urged that we take our Christ, Charlie, of course, off the cross. Others were more topical, even reasonable. How can Kissinger go to the Mideast one week to negotiate peace and the next week go right back to there and sell arms? She asked, too many simple, childlike mind. I say no. Then there was the matter of President Ford. Lynn strictly adhered to Judge McBride's instructions not to discuss her case, but she deplored the president's call for building 145 new nuclear power plants. Nuclear power plants is dangerous. Nuclear power kills, said Lynn, and yet I saw a very secure, doctorly, fatherly man, President Ford, say this is perfectly safe. As Lynn was led away at the interview's end, Lynn pressed her face to the glass and mouthed the message. Lynn struggled to hear but couldn't make it out, finally throwing her hands up in frustration. Sandy said it again. Patty Hearst is busted. Lynn had another visitor, Clyde Blackmon. Judge McBride had asked the attorney to dissuade Lynn from trying to represent herself in court, so she confident that Blackmon would persuasively explain to Lynn the problems, the dangers, the pitfalls of taking her own case. He didn't even bother to ask Lynn her reaction when the court reconvened. After disposing of routine matters related to the case, McBride prepared to adjourn before the Friday lunch hour. Anything else to come before the court this morning? McBride asked. She wants to represent herself, Your Honor, Dick Walker reminded the judge. Could we deal with that? I don't know, said the judge. I thought it might have gone away. Laughs echoed through the courtroom. No, said Lynn, standing with her arms crossed. She wasn't laughing. It hasn't, McBride acknowledged. It has not gone away, Your Honor, said Walker. A judge can always hope and pray, McBride grumbled, and he asked Lynn if she understood the charge against her. From my understanding, said Lynn, it is up to the U.S. Attorney to prove that I intentionally went to the state capitol building with the specific intent of assassinating the president, or attempting to assassinate the president, McBride corrected. Well, that's all right, said Lynn. Okay, do you understand that the elements of the crime are? Do you know that the two things you have to prove in order to convict you of this crime? In layman's language, the thought and the overt action is that I understand must be proved. Have you ever represented yourself before any criminal charges or any criminal proceedings of this kind? Just in life, said Lynn. Just in life, the judge reported. All right. He asked if she understood the local district court rules or the federal rules of criminal procedure. No, I do not, said Lynn. Do you understand the nature of the bill of particulars? Do you understand the idea of motions for discovery? Do you understand what's involved in a motion for discovery? No, I don't, Your Honor, and I know nothing whatsoever about federal law and very little about state law. And that's the whole purpose of my questioning you, Miss Fromme, emphasized the judge, to point out to you that you do not know anything about the federal law. Lynn, however, insisted that she had represented herself as no attorney could speak in her voice. But McBride refused to see the trial as an opportunity for self-expression. He kept trying to persuade Lynn that Dick Walker could do a better job in protecting her rights. There is no doubt, Your Honor, that from the technical viewpoint, Mr. Walker could do a better job than I could. At the same, well, said the judge, if he can do it better than you can, why don't you want him to do it? Because the stranger must be mine. The strategy must be mine, she said. I feel I would have a tendency to be in contempt. Your Honor, if I am not allowed to say the things that I feel would speed up the trial, I don't understand your statement that you feel that you would be in contempt. If you held me down, if you do not allow me to speak for myself, I feel that I would feel an urgency to speak and not be able to do so. It would be very frustrating. McBride continued his questions. Did Lynn know how many peremptory challenges she had for potential jurors? No. Do you understand the hearsay rule? No. In fact, Lynn said, I do know anything about the law. McBride groaned. Every time you say that, Miss Fromme, that's what's worried me. If you do not know anything about the law, why are you trying to be a lawyer? I would rather learn on my way here, Lynn said. In order to grant Lynn's motion to represent herself, the judge would have to find that she made a knowing, willingly, and intelligent waiver of her rights to counsel. And after Lynn's performance Friday morning, McBride acknowledged that she makes a very convincing case. But to be sure that Lynn was competent to make that choice as well as to stand trial, he decided to order a psychiatric examination of the defendant. Lynn was reluctant to ever talk to a psychiatrist, fearing that her words would be taken out of context. Moreover, with Phil Shelton had explained to Lynn the consequences of being found unfit to stand trial was worse than conviction. Under federal law, she would be committed to a mental hospital until authorities concluded she was competent, and then would stand trial. Lynn agreed to the examination. She insisted, however, that there be a witness present, Dick Walker or a deputy federal defender, Bob Holy, and that the interview be taped, just in case the psychiatrist left anything out. Not wanting to destroy his rapport with Lynn, McBride agreed. After an hour and 45-minute interview, Dr. James Richmond concluded that Lynn was mentally competent to stand trial and to waive her rights to counsel. Having set forth a new ground rules, Judge McBride granted Lynn's request to represent herself in court and appointed Dick Walker her co-counsel. We're going to leave it here for another day, and we can see what's going to happen with the Fool for a Client. If you think there's any truth and like or enjoyment here, please like and subscribe, and have a good day.